Hi class, good day. Welcome to Legal Aspects in Hospitality and Tourism. And now we are in the second part of our topic, the law on obligations and contracts. So gaya ng sinabi ko nung first topic natin, ito ang magiging part 2 natin and we will focus on the contracts. Okay? So definition agad. So what is contracts? A contract is a meeting of minds between two persons whereby one binds himself with respect to the other to give something or to render some service. So what are the different classes of contract? Okay, so definition of terms muna tayo and different classes of contract. According to degree of dependence. So we have principal, that which can exist independently of other contracts. So example, contract of loan. So second, accessory, that which cannot exist without a valid principal contract. So example is contracts of guarantee, surety, pledge, and mortgage. So third is preparatory, that which is not an end by itself, but only a means for the execution of another contract. So contract of agency naman ang magbibigay natin example for preparatory. Okay, next, according to manner of perfection. So we have two classifications here, consensual and real. So for consensual, that which is perfected by mere consent. So example, contract of sale. For real, that which is perfected not by mere consent, but by the delivery of the object of contract. So example na may bigyan natin dito ay contracts of deposit, pledge, mutuum, and commutatum. Next, according to nature of obligation produced. Bilateral, that which creates obligations on both sides or on both parties. So another example is contract of sale then. The second one is unilateral, that which creates obligations only on one side or on the part of only one of the contracting parties. So, example is contract of commutatum. So, mapapansin nyo na ulit na lang ito, pero kasi tinitignan natin dito yung different classes of contracts according to their name. Okay, nominate, that which is distinguished by a particular or special name in the civil code. So ano mga yun? Contract of sale, lease, trust, deposit, comodato, mutuum, agency, partnership, and insurance. So for innominate or innominado, that which is recognized in the civil code but not especially named or classified in the said code. So hindi nababanggit dun sa code na ito. So we have four kinds here. Do ut des, I give that you give. Do ut facies, I give that you do. Facio ut des, I do that you give. And the last one is facio ut facias, I do that you do. Next, according to cause, we have three classes here. First is onerous, that where the cause is understood to be for each contracting party the prestation or promise of a thing or service by the other. So for example is contract of sale. Second one is remuneratory, that which the cause is the service or benefit for which the remuneration is given. Example is remuneratory donation. And the last one is gratuitous, that where the cause is the mere liberality of the benefactor. For example is contract of comodatum. Next, according to risk involved, we have two kinds here, commutative and aleatory. So first, in commutative, that in which each of the contracting parties gives and receives an equivalent or there is a mutual exchange of relative values. For example, is contract of sale. Now for the second one, that in which of the parties or both reciprocally bind themselves to give or to do something in consideration of what the other shall give or do upon the happening of an event which is uncertain or which is to occur at an indeterminate time. For example, is contract of insurance. Okay, Last one, according to the requirement of form or solemnity. So we have common and special or solemn. For common, that which does not require any form. For special, that which requires certain formalities either for its validity or enforceability. Okay, so ang daming classes ng contracts na nabanggit natin kanina. So these are the stages in life of a contract. So paano nga ba nabubuo at paano nagtatapos ang isang kontrata? So first, preparation. This includes all the steps taken by the parties leading to the perfection of the contract. At this stage, the parties have not yet arrived at any definite agreement, pero nagkakaroon ng preparasyon para magkaroon ng contract. Okay? The second stage is the perfection, the birth, the formation of the contract. This is when the parties have come to definite agreement or meeting of the minds regarding the subject matter and cause of the contract. So kung ano nga ba yung mangyayari dun sa contract na yan, so nagkaroon na tayo ng birth ng contract. So that is the second stage. And the last one is the consummation, death, extinguishment, paano matapos ang contract nito. This is when the parties have performed their respective obligations and the contract may be said to have been fully accomplished or executed, resulting in the extinguishment or termination thereof. So ngayon, pag-usapan naman natin ang common characteristics ng isang contract. So meron tayong mnemonics na ginagamit dito. We can call this MARCO, okay? So MARCO stands for mutuality of contracts, autonomy of contracts, relativity of contracts, consensuality of contracts, and obligatory force of contracts. So madali lang maintindihin ito. So we have definitions of these concepts. First, mutuality of contracts. It is the validity and performance that cannot be left to the will of only one of the parties. So mutual from the word itself. Purpose is to render void contract containing a condition which makes fulfillment dependent exclusively upon the uncontrolled will of one of the contracting parties. So second, we have autonomy or liberty of the contracts. So from the word itself, autonomy, liberty, meron kang kalayaan dun sa pag-stipulate ng kontrata. Entering into contract is a guaranteed right of the citizens. They are free to do so as long as it is not contrary to law, good morals, customs, public order, and public safety. So bahala kayo kung anong gagawin nyo sa kontrata na yan, kung anong mapag-usapan nyo, as long as it is not contrary to law. Mayroon kayong kalayaan kung anong gawin dyan. Okay, next is the relativity of contracts, binding only upon the parties and their successors. Contracts take effect only between the parties, their assignments, and heirs. No one may contract in the name of another. Okay, consensuality of contracts. Article 1315, contracts are perfected by mere consent, and from that moment, the parties are bound not only to the fulfillment of what has been expressly stipulated, but also to all the consequences which, according to their nature, may be in keeping with good faith, usage, and law. So itong tinatawag na consensuality, consent na pagpapasok kayo sa contract na to, dapat aware kayo sa mangyayari consequences ng kontrata. Okay? Obligatory force of contracts. It constitutes the laws as between the parties. So we have two provisions here, Article 1308 and 1159. So for Article 1308, the contract must bind both contracting parties. Its validity or compliance cannot be left to the will of one of them. So Article 1159, obligations arising from contracts have the force of law between the contracting parties and should be complied with in good faith. Okay, now let's move on to the essential requisites of contracts. So there is no contract unless the following requisites concur. So dapat, para magkaroon tayo ng contract, ito ay masunod. Masunod dapat ang tatlong babanggitin ko. So first, consent of the contracting parties. So C, pakatandaan yung consent. Second one is object certain, which is the subject matter of the contract. Pakatandaan yung letter O. And third, cause of the obligation which is established. Consent, object, and cause. So pwede natin gamitin dito ang mnemonics na COC for essential requisites of contracts. So what is breach of contract? Breach of contract is defined as the failure without legal reason to comply with the terms of the contract. Yan ang tinatawag natin na breach of contracts. Now, let's move on to defective contracts. So, there are four classes of defective contracts under the present civil code. So, they are first, resistable contracts. Second, voidable contracts. Third, unenforceable contracts. And fourth, void and inexistent contracts. So, i-define natin isa-isa yung nabanggit ko kanina. For resistable contracts, it is a contract which is valid because it contains all of essential requisites prescribed by law, but which is defective because of injury or damage to either of the contracting parties or to third person, as a consequence of which it may be rescinded by means of a proper action for rescission. Voidable contracts are those in which all of the essential elements are for validity are present, but the element of consent is vitiated either by lack of legal capacity of one of the contracting parties or by mistake, violence, intimidation, undue influence, or fraud. So, voidable contracts, magbibigay ng example. Okay naman yung kontrata, pero yung isa sa involved na party, sabihin natin, hindi pala sa legal age. Sabihin natin, minor sila. So, hindi sila pwedeng pumasok sa kontrata since they are not on their legal age. Kaya tinawag itong voidable contracts. The third one is unenforceable contracts. Those which cannot be enforced by a proper action in court unless they are ratified, because either they are entered into without or in excess of authority, or they don't have complied with the statute of frauds, or both of the contracting parties do not possess the required legal capacity. So last one is void or inexistent contracts. In particular, void contracts are the contracts where all of the requisites prescribed by law for contracts are present, but the cause, object, or purpose is contrary to law, morals, good customs, public order, public policy, or they have prohibited by law or they are declared by law to be void. Next concept, we have natural obligations. So what is natural obligations? Those obligations are based on equity and natural law, which are not enforceable by means of a court action, but which, after voluntary fulfillment by the obligor, authorize the retention of the obligee of what has been delivered or rendered by reason thereof. So, ang hirap maintindihan ng natural obligations na to, pero madali lang kapag magbibigay tayo ng isang example. Okay, for example, A borrowed 10,000 pesos from B, which amount B failed to collect. So, hindi na-collecta ni B yung hiniram ni A na 10,000. After the debt prescribed, A voluntarily paid B who accepted the payment. So, nag-volunteer si A na bayaran. After a few months, being in need of money, A demanded the return of the 10,000 on the ground that there was a wrong payment. The debt having already prescribed, B refused to return the amount paid. May A succeed in collecting if he sues B in court? So, gustong bawiin ni A yung binayad niya kasi feeling niya siguro nakalimutan naman sana ni B yun pero bakit nag-voluntary pa siyang magbayad? So, gusto niyang bawiin yung 10,000 kasi need niya yung pera. So, what if kung si A nagreklamo sa korte and he sues B? Ano ang papanigan ng korte? A will not succeed in collecting the 10,000 if he sues B in court. The case is expressly covered by Article 1424 of the Civil Code, which declares that when a right to sue upon civil obligation has lapsed by extintive prescription, the obligor who voluntarily performs the contract cannot recover what he has delivered or the value of the service rendered. So, yun ang tinatawag natin na natural obligation. Paano niya irereklamo si B na kukunin niya yung pera, natural obligation na yon na bayaran talaga yung utang niya kay B. Because of extinctive prescription, the obligation of A to pay his debt 10,000 to B became a natural obligation, cannot be enforced by the court action. Nevertheless, after voluntary fulfillment by the obligor under the law, the obligee is authorized to retain what has been paid by reason thereof. Okay, so that is for the part 2 of obligations and contracts. Thank you.